Zachary James versus Brianna Burge.
For the record, this matter is before the courts for continued pretrial conference subject to scheduled mediation. And this hearing is being conducted via Zoom. Present is Attorney John Danielski, representing the plaintiff, Zachary James. Mr. James is present. In addition, Attorney Logan Francisco, representing the defendant, Brianna Burge, is also present. Is Brianna Burge present in audio?
She is not, Your Honor.
Okay. Can you reach her? Text her?
I suppose I could, Your Honor. She's retained by new counsel now. So
First, I received an appearance. If she has not appeared this morning, the court's can enter default against her. And if in fact we adjourn this matter, I want to take the proofs. So Ms. Francisco inform her that if she does not appear next 5 minutes, the court's going to default her.
I understand. I'll give her a call right now, Your Honor.
Thank you. Mr. Danielski, have you had any contact with another attorney?
No, what's going on, Your Honor, is Mr. Francisco notified me Friday late in the afternoon that she had retained new counsel. My client indicates that she's upset that she has to answer my 13 discovery questions, and therefore was complaining about that. And so she's not here.
Did you have any contact with the new attorney? Have you received an appearance?
There's no appearance filed that I'm aware of. It's a Jennifer Winstead out of Waterford. And I know Miss Winstead was informed of this because Mr. Francisco emailed her and me at the same time, telling her about it. And obviously Miss Burge knows about it because she was here last week. And we did send discovery questions in February. We still haven't gotten answers. Your Honor signed an order for the discovery. We have provided discovery. We haven't gotten any yet.
I'm sorry, there was a motion hearing last week. There's nothing in the court file reflecting that.
Your Honor, there was a stipulation, and my runner indicated he brought the order down to the court by me and Mr. Frank. I assume Your Honor signed it. Your Honor,
you indicated she was present last week for a hearing.
She was here. Yes, we came. We were with Miss LaPrade last week, and we mediated for a little bit. But Mom has a business with over $500,000 in revenue pursuant to my client, and I just needed, assets, bank account information, basic information that I was asking for. The stuff you would basically, the VFIF is what my questions were, and
all right, the court recalls that now. Yes, it was scheduled for April 22nd. There was a snafu, so it was adjourned for 1 week. And but Miss Burge was not present last week, Mr. Danielski. But Mr. Francisco, any luck in reaching her? Yes,
I just got off the phone with her. I forwarded her your Zoom ID. She should be getting on any second now.
Thank you. Any objection to what I'm going to explain to the court? I take the proofs and can you get the other attorney on board? I mean, the attorney should be here. I'm not going to schedule.
I understand, Your Honor.
All right, Miss James, are you Brianna James?
Yes, sir.
Call your new attorney. She's got to be here this morning. Have her zoom in. Otherwise, you're going to be defaulted. You're creating a lot of delays for this court.
I do apologize, sir.
Call her right now. Tell her, give her Zoom ID number. She's got to zoom in. Otherwise, you're going to be defaulted.
Yes, sir.
Okay, so reach your attorney. Tell her to zoom in immediately.
Sir, she just texted me and said that she's logging in now.
She should have logged in at 8:30, Miss James, and so should you have. You're ignoring orders of this court.
I do apologize, sir. I talked to her this morning and she said that that Mr. Francisco was going to take care of it and that I did not have to be present.
Okay.
So I do apologize. This is one of the reasons why I retained a new attorney, sir.
Right. Are you Jennifer Winstead?
Good morning, Your Honor. I am.
Good morning. I'm informed that you've been retained by Brianna Burge.
Yes, sir. And I apologize. It was very late in the day on Friday and I was in a trial all afternoon on Friday. So I was not able to get the substitution of attorney over to Mr.
That's
Francis.
fine. That's fine, but you should have appeared this morning to inform the court as a courtesy. There was marriage scheduled for mediation this morning. There's a pretrial. So at this point in time, I thank you for appearing. The court would like to take the proofs. I'm going to reserve all issues. We're going to take the proofs to establish jurisdiction. There's a breakdown that Ms. James is not pregnant, unless you have an objection to that. And then I will review with you and Mr. Danielski your schedules for another mediation with Ms. LaPrade. I need to move this case along.
That's no problem, Your Honor. And I apologize. I wasn't even aware that there was anything this morning other than the mediation that Mr. Francisco said he would have adjourned. So I do apologize.
Ms. Burge should have informed you of that. All right, Mr. James, Ms. Burge, can you both please raise your right hand to be sworn?
I do.
Can't hear you?
I do.
Thank you. Then we can hear you now. All right, Mr. Danielski, if you can just take the basic proofs. There's the established jurisdiction. There's been a breakdown. There's no minor children, so forth, please.
For Your Honor, Mr. James, did you live in the state of Michigan for 180 days consecutively before the case was filed?
Yes.
Did you live in Monroe County for 10 days consecutively before the case was filed?
Yes.
Were the allegations in the complaint that was filed true?
Yes.
Are they still true today?
Yes.
Is there any chance of reconciliation between you and Ms. Burge?
No.
And do you and Ms. Burge have any minor children together?
No.
To your knowledge, is Ms. Burge pregnant?
No.
I believe that satisfies it, Your Honor.
Thank you, Mr. Danielski. Ms. Winstead, do you have any questions, Mr. James, regarding the proofs?
No, sir.
All right, if you can simply voir dire Ms. James, Ms. Burge, that she's not now pregnant, please.
Sure. Ms. Burge, can you please state your name for the record?
Brianna Burge?
And at this time, are you currently pregnant?
No.
I have no further questions, Your Honor.
Thank you. Do you have your schedule, Ms. Winstead? The court would like to schedule another mediation with Ms. LaPrade.
Yes.
I know there's some outstanding interrogatories. There was an order entered that those would be answered within a specific time frame. I don't recall that time frame. Have you received those answers yet, Mr. Danielski?
No, they were due yesterday, and the discovery was sent over 2 months ago.
Okay. So, Ms. Burge, you need to meet with Ms. Winstead this week and go through those interrogatories so those can be responded to.
Yes, sir. I just received them last Thursday. So I do apologize for all the miscommunication, but this is one of the reasons, sir, why I hired a new attorney. There was no communication. I wasn't getting the right documents. There was no response. So I do apologize for the inconvenience.
Okay, but please meet with Ms. Winstead this week and provide those interrogatories. Mr. Danielski, perhaps you can email those to Ms. Winstead so that those can be addressed this week.
I'll email them in the court order, Your Honor.
All right, thank you. Ms. LaPrade, good morning.
Good morning.
We've taken the proof, so it gives us a little bit of breathing room for another mediation date. We have a short-term marriage here, a year and a half. I think the only issue is some personal property division, and then there's a marital home, inherited property. There's real estate, one of which is inherited property up north, but obviously it's the parties are separated, short-term marriage. When are you available for mediation, Ms. LaPrade? I have a list. I'm not sure how updated this is. Perhaps we go toward end of May or early June.
Your Honor, depending on when the attorneys can be ready, I have some Monday availability that we could work out.
Well, Ms. Winstead is new, so she's got to catch up, and obviously there's interrogatories that need to be answered. So are you still available on, let's say, May 23rd?
At 1:30 in the afternoon, Your Honor, I am.
I'm available that day, Your Honor.
Okay.
Yes, I guess I can make it. Is there?
We'll go June 7th. If May 23rd is not good, Mr. Janowski, we go look at June 7th.
That would be better, Your Honor. I have a felony criminal trial right around that date. So, but June 7th is good. June 7th works.
Yeah, but it's in the afternoon. I'll not be available in the afternoon at June 7th. So I guess how about the 13th of June at 8:30?
Your Honor, we could do June 3rd if the attorneys are available.
You
June 3rd,
know,
Monday?
Yes,
that's the date of my criminal trial. Your Honor, I can make it happen on the 23rd in the afternoon.
Okay, so May 23rd at 1:30. Ms. Winstead, there'll be a Zoom mediation with Mr. Pratt. The court will mail out notice. Can you, I guess I don't have your address. I guess I get it from the bar directory. Yeah, we'll get it from the bar directory. So we'll send out notice that the party shall mediate with Mr. Pratt on May 23rd at 1:30 via Zoom. We'll provide you in that notice with Ms. Pratt's Zoom ID number. And after the mediation, then they'll be appearing before the court for a continued pretrial conference. Whether it's 2:30, 3 o'clock, 3:30, 4 o'clock, whenever it's done.
Okay.
All right, anything further, Mr. Danielski?
No, Your Honor.
All right, thank you, Mr. Francisco, for reaching out to Ms. Burge. And thank you, Ms. Winstead, for appearing at short notice. I just sort of surprised you all this morning. So in any event, we'll see everyone on May 23rd, subsequent to the 1:30 mediation. Thank you, Ms. Brad.
thank you, Your Honor.
All right, everyone can zoom out. Have a good rest of the day.
Thank
Thank
you.
you.
Thank you, Your Honor.
Thank you.
Welcome. For the record, this matters before the court. I believe the purpose of putting a settlement agreement upon the record, as well as taking the proofs. And this hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff Todd Lambert. Mr. Lambert is present with Ms. Zagorski. In addition, Attorney Scott Longton is present with the defendant Jamie Lambert. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Is that the correct situation, Ms. Zagorski? The parties have reached agreement that they wish to place on the record this morning.
Yes, Your Honor, I have a judgment that has been signed by everybody. We are going to, with your permission, not have it entered by you until August 31st to allow Ms. Lambert to continue her health care coverage. And we're also asking that the trial that's scheduled for June 20th be vacated.
Wonderful. Thank you, Ms. Zagorski.
That's correct, Your Honor.
All right, thank you, Mr. Longton. All right, so Ms. Zagorski, you want to put the agreement upon the record?
Yes, just
Necessary? If everyone's, I suppose, I'll leave it to you whether or not you want to put it on the record to warn your client, or if they've already approved everything, it's not necessary from the court's perspective. I'll leave it to counsel.
do you have a preference, Scott?
I don't know. They've signed it, so I'm satisfied. You know, we can rely on the signatures of the judgment.
Okay, then I'll just
Right.
simply take the proofs.
All right, and you can maybe hit this, maybe warn them about the highlights of the judgment. Anyway,
Okay.
Mr. and Ms. Lambert, can you both please raise your right hand to
do.
be sworn, Mr. and Ms. Lambert? Thank you. All right, Ms. Zagorski, you better begin with Mr. Lambert, please.
Yes, thank you, Your Honor. Would you please state your name for the record?
Todd Allen Lambert.
And do you remember signing a complaint for divorce November 20th of last year?
Yes,
At the time you signed that complaint, had you been a resident of the county of Monroe in the state of Michigan for 180 days?
yes,
And to the best of your knowledge, is your wife pregnant?
no,
And you two did not have any children during your marriage, correct?
no,
Didn't adopt any children?
No.
And is it true that there's been a breakdown in your marriage relationship?
yes,
Have the objects of matrimony been destroyed?
yes,
Is there any likelihood whatsoever that this marriage can be preserved?
no,
And you are familiar with the terms of a judgment of divorce?
yes,
And you signed that judgment?
yes,
You understand that that judgment is going to bar spousal support, and you can never come back and ask this court to award you or your wife spousal support. You understand that?
yes,
You understand that you are being awarded the marital home, and you are required to pay Ms. Lambert $10,000 within 60 days of today's date.
yes,
You understand that the marital portion of your retirement, half of that through March 31st of this year, will be awarded to your wife, and we will have to enter a qualified domestic relations order to do so.
yes,
And you understand that you're going to pay for half of that and half of any fees that are charged by your plan administrator to enter that quadro.
yes,
Okay. And you two have divided your personal property
yes,
to your satisfaction.
yes,
And in fact, Ms. Lambert has vacated your home,
yes,
and you intend to honor the agreement as you understand it.
yes,
And you understand if the judge enters it today, it will be binding upon you, and you cannot come back and ask this court to change it.
yes,
Do you believe that the terms in this judgment are fair and equitable?
yes,
Do you have any questions?
no.
I have nothing further, Your Honor.
Thank you, Ms. Zagorski. Mr. Longton, do you have any questions, first of all, for Mr. Lambert?
No, Your Honor.
Questions for Ms. Lambert, please.
Yes, thank you, Your Honor. Ms. Lambert, you understand that you have signed this judgment of divorce, correct?
correct.
And you understand that you have waived your right to modifiable spousal support, and spousal support is forever barred.
Yes,
You understand that you have waived your right to trial. You understand that had you gone to trial, Judge Braunlich could have awarded something similar or different, which could have been better or worse for you.
Yes.
You understand that this is full, final, and binding, and you cannot come back and ask the court for modification of the terms of this judgment later.
Yes.
All right. Do you believe that this judgment is fair and equitable?
Yes.
All right. Nothing further, Your Honor.
Did you confirm that she's not now pregnant, Mr. Longton?
I did not. I apologize. Are you currently pregnant? Thank you.
All right, thank you, Mr. Longton. Ms. Sikorsky, do you have any questions of Ms. Lambert?
I do not. Thank you.
Very well. With this agreement, the court will vacate the trial scheduled for June 20th, 2024, at 8:30 a.m. Court would like to thank and acknowledge Ms. Sikorsky and Mr. Longton for their fine efforts in helping facilitate amicable resolution between the parties. Ms. Lambert, you've been well served by two very capable practitioners. The best resolution of matters of this nature is one which you both participate and agree upon. Far better off than this court making these decisions at a trial. Based, however, on the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. Unfortunately, there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of that consent judgment, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved. Judgment shall enter, granting a divorce and bonds of matrimony. Good luck to both of you. Thank you again, Ms. Sikorsky and Mr. Longton. Zoom out. Have a good rest of the day.
Thank you. Have a good day, Your Honor.
Thank you.
Gina, are you able to text him and let him know that we're waiting for him?
Ma'am, we have a no contact order.
Okay.
Okay.
Okay. Right? Can you hear me?
Mr. Georges, can you hear the court?
Yes, sir. Now I can hear you, Your Honor.
Okay, good.
Court is now in session. Gina Alteen Georges versus Ronald Alteen Georges.
For the record, this matter is before the court for continued pretrial conference subsequent to the parties have mediated with Mr. Walker for the front of the court. This hearing is being conducted via Zoom. It appears that both parties are present. The plaintiff, Gina Alteen Georges, and the defendant, Ronald Alteen Georges. Good morning, everyone.
Good morning, Your
Honor.
The court has been informed, Mr. Walker, the two of you have reached your own agreement. Is that correct?
Yes, sir.
Your Honor.
George, you submitted a proposed default judgment, so we'll need a revised judgment. I don't know to what extent that the consent is different from your proposed default. If you want to pick up this default judgment form, you can do that. It's in the court file here. But since you're the plaintiff, you'll need to submit another form judgment. The court's going to have Mr. Walker state what he understands to be the party's agreement. So have both of you listen carefully. And Mr. Walker will place agreement on the record, and I'll confirm that with both of you. All right, Mr. Walker.
Yes, Your Honor. The only thing at issue with this divorce action, I believe, was debt. There is a personal loan that has approximately $8,000 still left owing on it that plaintiff has agreed to pay $3,000 towards. There's a MasterCard rewards credit card that has an approximate value of $15,000 that wife has agreed to pay $3,000 also on that. So for a total of $6,000, and wife has agreed to pay $50 a month to husband directly until that debt is paid in full. There is also a fifth wheel that has been repossessed. The parties are not 100% sure what that debt is yet. The repossessor is going to sell that vehicle, take the proceeds from that sale off of the debt, and then let them know what that debt is. Once the debt is established, the parties have agreed that they are going to split that debt in half, 50-50, and each party will pay their half of the debt directly to the debtor. Any other debts that are in either party's names, they would keep and be responsible for. Spousal support, there will be none. It is forever barred. And all other issues, specifically personal property, bank accounts, retirement accounts, vehicles, life insurance, all of that has already been split. And each party will keep whatever is currently in their possession or in their name. There is no real property to divide. And plaintiff would like her name of DeMiros restored. I believe that is the extent of the agreement, Your Honor.
Oh, can I say something?
Yes, please.
I didn't know the default of judgment could still consist.
Well, it's in the file, but the court would not enter that this morning because Mr. George has appeared.
Okay, thank you.
Right. So we were hoping that the court prefers that parties participate. So, Mr. Walker, there are 3 debts then, correct? there's a debt on the open range trailer coach, and the parties will share equally any deficiency judgment or liability on that loan. Is that correct?
That is correct.
And then there are two other loans. One is a personal loan. Well, first of all, can we establish to whom is the debt owed on the trailer coach? Who's the debtor? Is it the credit union one?
I believe so.
Mr.
Yes,
George,
Your
would you
Honor.
agree that debt on the coach is credit union one?
Yes, Your Honor.
Okay, so the judgment of divorce, Ms. You're going to prepare, Mr. George should say that the trailer coach debt to credit one, you should identify credit one as being the debtor. Or the creditor, I should say. Credit one, it's credit union one, I should say.
Yes, Your Honor.
You'll share equally that once you know it. And the other two loans, one's a personal loan, and to whom is that you're going to share? You're going to Miss George, you're going to pay $3,000 toward that. Is that correct,
Yes.
Mr. Walker? And
Yes, Your Honor.
who is that personal loan owed to?
Credit Union one, Your Honor.
Oh, okay. So you have more than one loan to credit union one.
Yes, Your Honor.
Okay. Okay, and there's a third debt, Mr. Walker.
Yes, Your Honor. That's a MasterCard rewards credit card.
Okay. In terms of, can you once again repeat the agreement relative to the personal loan to credit union one? The plaintiff will pay $3,000 that, $50 a month?
That is $3,000 towards each debt for a total of $6,000, and will be paid at the rate of $50 a month to Mr. Georges.
Total of $50 a month or $50 on each loan?
Total of $50 a month, Your Honor.
Toward a $6,000 indebtedness?
Correct.
Okay. We should probably establish, will that be due what, the first of the month? To begin May 1st, for example?
Can you do the 15th of each month?
No, the 15th is not.
Oh, well,
Okay.
which one?
Probably the first is better.
Okay, the first, Your Honor.
Right.
Like,
So
or
Mr.
June
George, is that
1st?
agreeable? Then Miss George will pay $50 a month?
Yes, and for the record,
First?
and for the record, when she can't pay it, for the record, I'm not going to try to come at her. I want the record to show that when she pays it, she pays it. If she can't, she can't.
Well, we need to put something in writing in the judgment. So we'll put $50 a month commencing May 1st. And how will you make that payment? By check, or you can make a direct electronic transfer?
Your
Ms.
Honor,
Burgess?
can you start that June 1st? Because
You don't have $50.
I don't have $50 right now.
Mr. George, is that agreeable that the first payment begins June 1st?
Yes, Your Honor.
Okay, Ms. George's, the last issue, are you still receiving public assistance?
Repeat that, sir.
Yes. Ms. Gina, you should receive public assistance.
No.
Okay, well, you, when you filed this divorce complaint, you got a fee waiver, you're alleging to the clerk that you're on public assistance. There's a fine fee due of $175, and that needs to be paid. So if you're not in public assistance, unless Mr. George is willing to pay that.
Okay.
$175, and I'll give you as much time as you need to pay that. If you recall, Ms. George, when you filed this, you informed the, the court actually suspended and reserved the payment of filing fee to be reviewed at entry of time of judgment. So yes, you're not a public assistance, but because you had insignificant income, the court allowed you to proceed with the divorce without having to pay that filing fee. So this judgment will have to reflect, someone's got to pay the $175 filing fee, and I will give you as much time in which to pay that. It sounds like are you currently employed, Ms. Georges?
Yes, sir.
Okay. Okay, you have to pay that? Do you
Is there
want to
any
share
way-
that cost?
Can we share that cost, please?
Mr. Georges?
Your Honor, I'm going to be releasing her of 5 debts totaling over $30,000. So I would not agree with that. I'm going to read. Yeah, I'm releasing her of a huge amount of debt.
All right, so, but you're gainfully employed, Ms. George, I'll give you as much time as you need to pay that. What if I gave you till, say, June 28th?
Okay.
So you need to put in the judgments. There's an open area, paragraph 18. If you'll see, there's a white space there. Just indicate plaintiff, you're the plaintiff, shall pay $175 filing fee to Monroe County Clerk on or before June 28th.
Okay, sir.
And the county clerk is in the same office where you filed your paperwork. If in fact you can't pay, you call the court, and I'll give you another month. Just don't blow it off. If you blow it off, that's when bench warrants issue. We don't want bench warrants issued for your arrest, ma'am. So the court will work with you. But they will not accept partial payments. You got to make the whole payment at one time, $175. If you pay, you can pay by credit card over the phone, but they're going to charge you a 3% fee. You're best off just paying cash so you can avoid having to pay any additional credit card fee.
Okay, thank
so
you.
Make a note there, $175 filing fee due to Monroe County Clerk on or before June 28th. And all you got to do is call the court if you cannot pay it, and I will give you another month. Just do not ignore that. So that needs to be included in the judgment, paragraph 18. So I knew that the court was aware that this trailer coach existed, but that's gone, right? Someone, Credit Union 1 has taken possession, repossessed that camper. Is that correct?
Yes, Your Honor.
All right. So, Ms. Georges, you'll need to revise this judgment. All you got to do is, I think you want to attach to it what's called a debt addendum. You can find that online too. If you can't find it, you come down to the courthouse, Judge Bronx Courtman, we'll provide you with these forms. There's the 2-page judgment divorce, and you want to do, actually, yeah, you actually attach a debt addendum where you reference the trailer coach, and you can spell out these different debts in there. That you'll share equally the debt on the due to Credit Union 1 for the trailer coach. You will pay Mr. Georges a total of $6,000 at the rate of $50 a month, commencing June 1st, 2024. Everything else can be similar to your prior default judgment. So if you need help with those forms, come down to the courthouse. We'll give you the forms. If you can't find them online, okay?
Yes, sir.
Then you need to sign your name, the bound page 2 of the judgment, and date it. Then you need to get it to Mr. George for his review and approval. The court will not be divorced until the court signs the written judgment. So maybe you can meet Mr. Georges for coffee, or if you want to meet down at the courthouse together, whatever is easiest for both of you.
Your Honor, do you have the form of judgment of divorce without children?
Yes.
And then I attach the revised judgment of divorce to that?
No, you attach to it the debt addendum, the personal, it's a form that you previously attached as judgment, divorce, no children, personal property, and debt addendum. So you can reference those debts in there.
Okay.
And tell me if no contact, how do you get it to run?
All right, you got a third party there. Hold on. This is between you and Mr. George. If there's a third party, that third party needs to remain silent.
Yes, sir.
All right, Mr. Georges, can you both please raise your right hand? Thank you. Ms. Georges, is it true that you filed a complaint for divorce with this court on or about December 21st, 2023?
Yes, sir.
Is it further true that on the date you filed that complaint, you'd been a resident of County Monroe for at least 10 days and stayed in Michigan at least 6 months?
Yes.
Is it true that you married Ronald Olteen Georges on July 22nd, 2022, and you separated in September of 2023?
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes, sir.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage?
No, sir.
Are you currently pregnant?
No, sir.
Do you have any questions for the court?
No, sir.
You had a question about a no contact order?
Oh, yes, sir. How would we go about signing these papers once I give them to you?
I'm sorry, how do you go about signing them? You just sign it. And then you need to you can meet Mr. George's or mail it to Mr. George's, or if you both want to come down to the courthouse and you can, outside the court's window, and you can both make sure that it's accurate and acceptable, and you can both sign it down here.
But I can mail it to.
I'm not aware of a no contact order. Did you get a personal protection order?
Yes, sir.
Okay. And that prohibits you from having any contact whatsoever?
Yes, sir.
All right. So I know what to tell you. Maybe have a third party. Maybe you got a mutual friend that can deliver it to Mr. George's.
Okay.
Or obviously you need to both make sure that it's accurate, accurately reflects everything that's been put in the agreement. You got to specifically address all this debt. Then you're not going to be divorced till you get to submit a fully approved judgment to the court. And obviously you want to get this done as soon as possible, correct?
Yes, I'll get it done as soon as possible.
All right. How are you going to get that to Mr. George? Is you going to have a third party take it to him?
Can I mail it to him?
You can. And then Mr. George's, when you receive the judgment, you need to get that either delivered to the courthouse or get it back to Ms. George's if it's acceptable.
Well, I signed the debt addendum. I don't sign divorce. I don't agree with divorce. It's against my religion, but I can sign the debt addendum and someone else can sign my name. I don't agree with divorce.
Your name, Mr. George. We need your signature to make sure that verifies that you have agreed to this, the settlement.
I don't agree with divorce. I agree to debt.
Ms. George is entitled to a divorce under Michigan law if she wants one.
Yeah, that's fine, but I can't sign it. It's against my religion.
Okay, you need to deliver that judgment to the courthouse and I can make sure that you have approved it.
Okay.
So if you don't want to sign it, you need to walk it down here and say, Judge Braunlich, I'm Ronald George's and here's the judgment.
Okay. I can do that.
Don't put on there they refuse to sign it.
Okay.
All right, Mr. George's, please state your name and current address for the record, please.
Ronald Olteen George.
Thank you. Mr. George's, did you hear the testimony of your wife, Gina, this morning?
Yes, Your Honor.
Was her testimony true and accurate to the best of her knowledge?
Yes, Your Honor.
Do you have any questions for the court?
I need a record that will help her here of, I need it on the record because she has her name on an American Express card with $11,000 debt. I wanted to make sure that it was on the court record that she's being released from that. Her name is and signature is on that credit card for American Express. Her name is also on a Home Depot card. I'm going to release her from that debt. And I'm releasing her of over $3,000 for storage while she was incarcerated at Tennessee, Warren County Jail for 14 days.
Right, hold on, Mr. George's. We either have an agreement or we don't. The agreement is that any debt in her name, she will pay.
Okay.
So if Home Depot, American Express are in her name, it's not your responsibility.
Okay. Okay. Oh, the court understands that. That's fine.
So you want to make sure that your judgment actually reflects that. Now, if the divorce says you pay the American Express, you pay Home Depot, that's why you want to review and you want to approve that judgment, Mr. George's. You're being told that and you say, oh, my religion doesn't agree with this. I'm not going to sign the judgment. Mr. George, you want to make sure that judgment accurately reflects your agreement.
Well, I just want to make sure she's covered. Her name's on these credit cards. So as long as you're telling me legally.
Mr. George's. Okay. Yeah. Mr. George's. Is your name on those credit card debts?
Yes.
The American Express?
Yeah, mine and hers.
You have to address all joint debts.
We did. I agreed to just accept this amount of money and wipe all of these.
I'm just informed of a debt to Credit Union 1 and a personal loan.
Yeah,
that she's going to reimburse you.
And in return, I'm letting all of these other debts go.
I don't know what you're talking about. Other debts go. My question is, you just raised a question about American Express card. And my question is, in whose name is that credit card debt?
Both of our names.
Okay, that's got to be addressed. Okay, what other, you got to address in your judgment of divorce all joint debts.
We did. Home Depot credit card in her name and my name.
Okay, Mr. Walker, did they bring to your attention Home Depot and American Express card, then what joint names?
Home Depot, Your Honor, I did not know was in both names. The American Express, it was my understanding that there was a card in Mr. George's name and a card in Mrs. George's name. Mrs. George's informed me that the card in her name was never activated, so she has no debt in her name with the American Express.
So as long as American Express is in your name.
Josh has all copies of the Home Depot. It's in that paperwork on the back pages is a copy of her name on a Home Depot credit card and her name and signature on the American Express. And I agreed to just take these three and remove all of these thousands of dollars of debt. There's a storage unit also, thousands of dollars of debt that was gotten. And we've agreed to just let all that go. I'm taking $30,000 worth of debt in exchange for what we agreed with you, Your Honor.
It's got to be spelled out in the judgment.
Okay.
That's why you need to review and approve this.
We just did what Josh said, Your Honor.
Well, but after you did that, you said, well, there's two other debts in the joint names. We need to address all joint debt. Spell it out.
Well, Josh, I assumed that that's what Josh was doing with these three debts, is making sure these other debts are not going to come after her.
Mr. Georges, maybe the two of you need to hire lawyers.
We can't afford it. I've had 9 surgeries, Your Honor.
Your Honor,
Okay, let me ask you again. Hold on. Is the American Express card in both names?
Yeah.
No.
Tell him it's a business.
It's a business card, Your Honor.
Right here.
Was a business card, a commercial card, personal card? Is it in both names?
Yes.
Yes, Your Honor. It's right here. Copy of all of them. The Home Depot with her name on it.
As long as we don't have an agreement. As long as we don't have an agreement, so let's just set this for a quick trial.
Okay.
Come on, you two. I mean, this is a 1-year marriage. The two of you can't reach your own agreement?
I did, Your Honor.
We did. He did. We agreed on these 3 things in exchange to remove all of this $30,000 of debt, Your Honor. We did.
Mr. Georges, we have to address in judgment of divorce any joint debt. Yes, any debt in your name, you pay. Any debt in Miss George's name, she'll pay. The agreement that I've heard is that there are 3 debts. One is going to share equally the debt to credit union, one on the trailer coach. You're going to share, and Miss George is going to pay $3,000 toward the MasterCard reward credit card. And then there's a $3,000, and she's going to pay $3,000 toward a personal loan. I'm not sure to whom that personal loan is due. That's I'll do the credit union one, correct, Mr. Walker? Yeah, so you have
Yes, Your Honor, that's credit union one.
There was no discussion agreement about American Express and Home Depot. So you're throwing a wrench into everything, Mr. Georges. You say the Home Depot is in both names?
Yeah, everybody has a copy of this. Everybody. Josh has a copy. Gina has a copy. Everybody has a copy of everything.
Court's not in receipt of such a copy, Mr. Georges. So I can't don't flash that because I can't read it on the screen. Ms. Georges, there's Home Depot in both names?
No. Josh has it.
Whatever that says, it says 2018, and we wasn't married to 2022. And that's it for his business.
Well, it doesn't matter.
No,
Was
Home
your name
Depot
answered
is
the card?
personal.
The judgment needs to address. Are you going to pay the Home Depot card, Mr. Georges?
Yeah, I'm going to take care of all this debt, Your Honor.
Okay. All right. So, Ms. Georges, in your judgment, you have to spell out Mr. Georges will pay the Home Depot and American Express card.
Okay. Josh didn't tell us that. We didn't know.
You didn't tell him that was a joint debt. So we got to spell out any joint debts. So in addition to the two debts, the credit union one and the debt to MasterCard, you need to put in the judgment, Miss Georges, that Mr. Georges will pay in full the outstanding balance of the American Express as well as the Home Depot card.
And
So
Dwayne Storage. And Dwayne Storage.
Okay, we don't have an agreement because Ronald's changing the whole agreement that we just did. So I
No,
asked
he
for a
did. He
default.
just was specifying, hold on, Miss Georges. You just got to put in the judgment that he shall be responsible for the American Express and Home Depot card because it's both names. Now, this storage expense is also both names.
The storage, we had both of our stuff. All her stuff when she was in jail was put in that storage.
It doesn't matter. Mr. Georges, the question, listen to the question. Is that debt in both names?
I haven't asked Dwayne if it's in both the names or not. He's the owner.
Well, have you gotten a bill in both names? Did Miss
Yeah,
Georges
she has
sign
a
a
bill.
contract?
She has a copy of it. It was given to her.
All right, to be on the safe side, Miss Georges, he said he'll pay it.
I will. I'm paying all
who's the
this.
creditor? To whom is the storage fee due?
Yes, I'm taking all of it.
Mr. Georges, what's
Yes,
the
sir.
name of the creditor?
Well, Dwayne Storage.
Okay, Dwayne Storage. So Miss George write in the judgment that he, Ronald will also pay the storage to Dwayne Storage.
Right.
Okay, then it will address that.
Okay.
Whether they're in both names or in one name, Mr. George will pay all those debts.
Okay, yes.
Okay. All right, anything further, Miss Georges?
No, Your Honor, that covers it.
So
Miss Georges, if you can't
Joshua
prepare the
and
judgment, if you can't prepare the judgment, contact an attorney. Attorney can help you prepare that. You're not going to be divorced till the court signs a judgment reviewed and approved by both of you.
yes, so we've agreed on $3,000 personal loan, $3,000 for MasterCard, and half of the fifth wheel.
Yes.
Correct. In addition, you've agreed that Ronald's going to pay the debt to Dwayne Storage, American Express, and Home Depot.
Yes, yes.
Okay.
So you got to spell that out.
Okay, yes.
Right. Mr. Georges, any other questions?
No, sir, Your Honor. Thank you.
Hey, come on, the two of you are adults. Work together.
That's why
Get
we're
this
getting
judgment entered.
Abuse.
All right. Thank you, Mr. Walker. And again, to make a note, you got to put in the judgment too, Ms. George, you're going to pay the $175 filing fee on them for June 28th. If you need to borrow that money, get that paid.
Yes, Your Honor.
Very well. Based upon the testimony, thank you, Mr. Walker, for your assistance. Based upon the testimony that's been presented this morning, as well as complaint filed this matter, the court finds that jurisdiction has been established and that there's been a breakdown of the marriage relationship to the extent that the opposite matrimony has been destroyed. There's no reasonable chance of reconciliation. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce with bonds matrimony. All right, that will conclude this hearing. You can both zoom out. Miss George, get to work on that judgment. If you need to come down to the courthouse, we can give you a copy of these forms. Okay.
Thank you.
Then either mail it to Mr. George's or have a mutual friend deliver it to him. Okay, right. You can
Thank you,
zoom
Your
out.
Honor. Thank you.
For the record, Mr. Allen is appearing via Zoom for the Monroe County Jail. Also present is Monroe County Family Court Attorney Rebecca Hicks. Mr. Allen, can you provide the court with an updated, please state your name and current address for the record.
Brian Allen, current.
Is that the address your office has on file for Mr. Allen, Ms. Hicks?
No, it is not, Your Honor.
Mr. Allen, you have an obligation to keep in front of the court informed of any change of address. So when you're mailed a notice to appear, mailed your old address, it's on you. So when you get out of jail, you need to come over to the front of the court and fill out a change of address form.
Yep, I will do that.
Right.
Can I ask,
I'm sorry?
Is the address on file 9? Because that's where I moved to recently. I moved from there to 512.
Yes, the
recently.
address we had
Yes,
was
I'm
9.
sorry. I did not know I had to update that. I will do that immediately.
Of course, some information regarding this file and Mr. Allen.
Yes, Your Honor. In this matter, there's a current monthly support obligation of $237 a month. The arrears are only $1,479. As it appears, we have been receiving payments through an income withholding notice that started based on a report to the National Hiring Database, which started, it looks like, in June of 2022. This bench warrant was issued after he failed to appear at a referee hearing in March of 2022. So we actually have been getting consistent payments for some time, but we've had zero contact with Mr. Allen, and we're not aware that those were coming in now.
Are you asking the court to commence contempt proceedings?
I would not, Your Honor, because of the fact that we've been getting payments consistently from income withholding for a period of 1.5 years. As long as he's going to still have his job, we would like to just cancel his bench warrant, release him from the jail so he can get back to work, order that he come back over here and update his address, and we'll just do an adjournment to make sure that he does maintain his job and those payments do keep coming in.
Right. Mr. Allen, do you have any criminal charges pending, anything else that's holding you in jail right now other than this friendly court bench warrant?
Not that I know of, no.
All right. Will you still have this job when you get out?
Yes.
Right. All right, so Mr. Allen, when you get out released, walk over to the courthouse this afternoon and fill out a change of address form. The court will follow Ms. Sick's recommendation. The court will cancel the bench warrant, authorize the release without having posted any type of cash bond. But we're going to give you a date to come back to appear for Ms. Sick for a review. You can appear by Zoom, and she just wants to make sure you're still making some regular monthly payments. What dates for the review, Ms. Six?
May 28th at 8 a.m., Your Honor.
Mr. Allen, you ordered to appear for Ms. Six, May 28th, 8 a.m. A copy of this order with that date will be mailed to you. One, of course, will also be faxed over to the jail. Hopefully you get a copy when you are released, but you'll be processed released in the next couple hours and get back to work and continue to make these. You got to pay a little more than $237 a month because you have to reduce these arrearages. So you can always pay a little bit more than what's coming out of your income withholding.
Okay.
Any questions?
No.
All right. Anything further, Ms. X?
Nothing further on this matter. Thank you, Your Honor.
Okay, Mr. Allen, if you have no questions, you can step out. Sir, can you state your name and current address for the record?
Oh, I'm sorry. Daniel Edwin Kosinski.
And all right, so for the record, Mr. Kosinski is appearing this afternoon from the Monroe County Jail via Zoom. I've been arrested on a bench warrant. Mr. Kosinski, do you have anything else holding you in jail today other than this Supreme Court bench warrant?
No, sir.
Okay. Ms. Six?
Your Honor, it's my understanding that Mr. Kosinski does have a felony non-support case with this as the underlying charge. I'm not sure if he was already arraigned on that yet today or is yet to be arraigned on it. This case does have a monthly support obligation of $607 a month and a current balance of $8,675.50.
Mr. Kosinski, are you aware that you're being charged by the State Attorney General with a felony non-support? It's now a criminal charge for which you can go to prison?
I did not understand that. No, sir. But I have been taking steps to get that done. I have a job close to my home that I was going to get paid today to start the process of paying back. I don't want to dissuade the court from anything, but the boy's mother has been doing some rehabilitation as well as what I was going to do. So,
right.
The motion.
So you've not been arraigned yet? You've not been arraigned yet on the criminal charge?
No, Your Honor.
All right. So you'll be arraigned that. Of course, we require that you post a cash bond, generally in about 25% of the arrearages. So this is where you got to reach out to family friends. So this court will cancel the bench warrant. Do you want to put this over for a day, Ms. Six, to see what kind of bond is set in the fund not support?
We can do that, Your Honor. The friend of the court would not be opposed to just setting it aside and allowing them to continue and us resuming enforcement upon adjudication. I did note from the AS 400, the proposed bond looks like it's $2,076.38. I don't know what exactly the judge will set, but they generally go somewhere around the proposed bond.
Yes, I believe the statute requires 25%.
Correct.
All right, Mr. Kosinski, you've got bigger issues than this court. This is a family court. This is a civil contempt. The most I can do is 45 days. You go to prison for the felony charge. You'll be arraigned later on this afternoon. And by statute, the court must set a cash-only bond, 25% of the arrears. So you're looking at about $2,000. So this is where you really reach out to family and friends to post that bond so you can get out and start to making payments for these arrears. That's you're clearing your best interest. Otherwise, you could be sitting in jail for a period of time. And especially if you got a job, you don't want to lose that job.
Yeah, I'm really trying. I'm really trying to get back on my feet and take responsibility.
Well, when you're unemployed, down in luck, that's when you reach out to the front of the court. The front of the court can assist you, but you're sitting on your hands. You could have filed motion reducers for those things you could have done, but you've done nothing. So unfortunately, you put yourself in that position. But this civil proceedings, we're just going to adjourn without date. We're going to monitor the felony charge. Okay. Any questions?
So this is going to continue to be a felony until I get this done. Like I get out and I start paying my arrearages, and this felony will go away, or is this going to be on my record? Because
it's going to be on your record, sir. Unless you can come up with, and you'll get an attorney in the it's a criminal charge. You'll get a court-appointed attorney. I suppose if you can come up with $8,000 paid off, the attorney general may drop it. But that you can talk to your attorney about that. Otherwise, very often once you post bond, you put on probation if you are convicted of this. So take one step at a time. I think your primary focus right now is reach out to family and friends so you can get this bond posted.
Yes, sir.
Unless you have other questions, sir, you can step out.
Thank you, sir.
Any other questions? Any other questions?
No, sir. No, sir.
All right. Good luck, sir. Our lost long friend Procopio-Vitali is surfaced.
Yes, I have 2 cleanup matters for him, if I may put those on the record.
Please.
Mr. Procopio-Vitali, there's 2 cases, Callie Pierce versus Procopio-Vitali and Nicole Dupuis versus Procopio-Vitali. Mr. Vitali has found himself incarcerated in the Washtenaw County Jail, facing criminal charges. We are not clear as to what a release date might be. So at this time, the front of the court is looking to cancel our bench warrant, set these matters over to July 17th at 8 a.m. so that we can monitor his incarceration and for any payments on these now arrears only cases.
And you're asking the bench warrant to be canceled?
Yes, please, Your Honor.
Will the notices be forwarded to the Washtenaw County Jail?
Yep, we're going to mail them to them. He sent a kite to the friend of the court on each of these cases. So we'll be sending a copy of these signed orders back to him through that method.
Very well. So ordered.
Thank you, Your Honor. And that's all I have today for cleanup.
Okay. Have a good afternoon.
You as well.
Sparks, they're reconciling and the plaintiff is in the hospital, so the plaintiff won't be shown. It'll just be Amber, Alex Dolan, and John. It's now in session. Amber Sparks versus Stephen Sparks.
For the record, this matter is before the court for continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom. Present is attorney Alex Goldman in place of Michael Keeney, representing the plaintiff Amber Sparks. Ms. Sparks is not present. Apparently she's has some medical issues. Is that correct, Mr. Goldman?
That's correct, Your Honor. She could be present if you desire, but she prefers to continue to rest.
Okay, but the defendant, David Sparks, is present. The parties did not mediate. So, Mr. Goldman, what's the status?
We'll be dismissing this case. I believe I can just do that unilaterally because no answer was filed.
Okay. You'll be submitting a dismissal order for the court. Is that correct?
Yes, Your Honor.
Okay. And the parties are going to attempt reconciliation, which is wonderful. Is that correct, Mr. Sparks?
Yes, sir. That is correct.
Okay. There's no need. You didn't file an answer, so you don't need to sign the stip in order. Mr. Goldman will prepare a dismissal for the court to sign. You'll be ultimately emailed a copy of that. So no need to reschedule this mediation, and the court wishes you the best in terms of reconciliation. So Mr. Goldman, you'll probably get that out this week. Is that correct?
I'll file it today, Your Honor.
Wonderful. Thank you, Mr. Goldman. Well, good luck, Mr. Sparks. We'll conclude this pretrial conference. Have a good rest of the day.
Thank you.
Thank you, Your Honor.